Hi, very good morning. It's a Supreme Court judgment under the Consumer Protection Act. Very interesting judgment. Venkataraman Krishnamurthy versus Lodha Crown Build Mart. That is the citation. In this case, Venkataraman, year after X, intended to purchase one apartment from the builder. They executed an agreement to sell. Sale consideration was rupees 7 crores approximately. So X was making the payments as per schedule. Last payment was to be made before initiation of the fit outs. X was throughout not at default in payment of the money. This is the accepted position. As per the agreement, apartment was to be delivered by 36 2016 and a grace period of 1 year was given, that is 36 2017. Builder took a grace period. Normally it is there in all the agreements. But apartment was not delivered by that time. So X cancelled the agreement and demanded refund of money with interest. So builder refused, then X approached the NCDRC. NCDRC issued the following directions. NCDRC said the builder should deliver the apartment complete in all respects within 3 months from the date of the order. Then the second direction was both of the parties, the builder should arrange for joint inspection. Any deficiencies are found, it should be rectified. That is the second direction. Third, the NCDRC said if the X, that is the purchaser, is not interested in taking possession even after completion and still seeks refund, the builder is entitled to deduct the earnest money deposit and then refund the balance amount within 2 months. These are the three directions given by the NCDRC. So X challenged the order of the NCDRC before Supreme Court. X said that its right to terminate the agreement and right to claim unconditional refund of the total amount is as per agreement. Supreme Court examined the agreement clauses. From the agreement clauses, two possible situations emerged. One is builder can inform the purchaser the revised date by which the unit will be ready. If the purchaser accepts it, then the contract would naturally stand extended. That is one term. Second is, upon expiry of the grace period, purchaser could elect to continue with the agreement. He may either continue with the agreement or terminate the agreement. It is not the builder's case that purchaser defaulted in payment. Contention of the builder was that it received occupation certificate for the apartment on 8/6/2017 and called upon the purchaser to make the balance payment. But still the purchaser failed to make the payment and hence the purchaser was at default. This is the case of the builder. As per the agreement, OC issued shall be deemed to be date of offer of possession. Another contention of the builder was purchaser wanted to back out of the contract because the levy of GST. It causes an additional burden to the purchaser. That is why he wants to back out now. That is the contention of the builder. Supreme Court perused the occupation certificate submitted by the builder and found it was not a full occupational certificate. It is a part occupational certificate obtained by the builder from the authorities. So the full occupation certificate, it is yet to be obtained by the builder. So the argument based on occupation certificate is a totally misconceived argument of the builder. That is what the Supreme Court says. NCDRC in its order said there was some delay in handing over possession and it was not unreasonable delay. Further, NCDRC directed in case refund is sought, earnest money can be forfeited. This we have already seen. Supreme Court held, these are all very important. Supreme Court held that once the parties committed themselves to a written contract whereby they reduce the terms and conditions agreed upon by them in writing, the same would be binding upon them. In the event such a written contract provided for the consequences that are to follow, and in the event of breach of conditions by one or the other of the parties, such consequences must necessarily follow, and if resisted, they would be legally enforceable. Very, very important. Once the parties enter into agreement, whatever consequences are specified in case of breach, that must follow. That is what the Supreme Court says. In this case, obviously, possession was not given by the committed date, by the builder. Right of election was given to the purchaser to terminate the agreement. This right is an absolute right. It was not open for the NCDRC to apply its own standards and conclude that though there was delay in handing over possession of the apartment, such delay was not unreasonable to warrant cancellation of the agreement. It was not for NCDRC to rewrite the terms and conditions of the contract between the parties and apply its own subjective criteria to determine the course of action to be adopted by the parties. Now, the Supreme Court states what is the principle behind the interpretation of contract. The principle is, in interpreting documents relating to a contract, duty of the court is to interpret the words in which the contract is expressed by the parties, because it is not for the court to make a new contract, however reasonable, if the parties have not made it themselves. Through interpretative process, the court cannot rewrite or create a new contract between the parties and has to simply apply the terms and conditions of the agreement as agreed between the parties. Court cannot substitute their own view of the presumed understanding of commercial terms by the parties if the terms are explicitly expressed. This is the principle behind the interpretation of contracts or the documents. Supreme Court further negated the contention of the builder that the purchaser accepted and accused with its proposal to dispense with the delivery of possession. Supreme Court said that mere exchange of correspondence by and between the parties prior to expiry of the grace period, when the purchaser was not even seized of all the facts, cannot be held against them. Supreme Court said the contention, one of the contentions we have seen, the builder said the purchaser wants to avoid the additional tax liability of GST. That is why he wants to withdraw and run away from the project. That is the contention of the builder. Supreme Court says in that connection, the purchaser was anxious to avoid additional tax liability owing to introduction of GST, cannot be held against them or be imputed to them as an underhand motive for backing out of the agreement. This is very important. Avoidance of tax is neither illegal nor equivalent to tax evasion, and therefore the urgency shown by the appellants, that is X in this case, in trying to complete the process quickly so as to avoid an additional tax burden was natural. This is what the Supreme Court says. Supreme Court said NCDRC overstepped its power and jurisdiction in ignoring the binding covenants in the agreement and in introducing its own logic and rationale to decide what the future course of action of the parties. Supreme Court directed the builder to refund the amount along with interest. It set aside the NCDRC's order. Interesting judgment. Thanks for your time. Have a great day.